Loud little ducky and her ducklings always seeking justice and truth. This ducky won't be silenced by the haters, seeking out the facts while providing the receipts. She is loud with her opinions in this cruel world of villains. This ducky will talk, give her sass, while still keeping her class. So join in the pond with the ducklings from all over the place.
Welcome to Loud Little Ducky. I am Ducky, of course, looking kind of pale. It's been a rough week for me, but we are going to go over things that we've missed in Owens-Verse, that we've missed there. Since we last streamed, we now have a response from the state in Gingras's attempt to appeal to the Arizona Supreme Court for his disciplinary proceedings with the state bar. And then some unknown body camera for a wellness check on Laura Owens done at the beginning of this year. And then we also have an end to the Chapter 11 bankruptcy with Elizabeth and Naylor Jan Black Owens the 12th and Ronn Owens, and how that ended. So lots to get through. And each of these in their own thing are not extremely long. The longest thing that we probably have is the disciplinary thing. But we shall see. So we're going to get the videos first, and then we will get to going over Gingras's bar thing as our last things. So let's bring up our thing. While you're coming in, do not forget to hit that like button. You can share this stream out if you would like. If you're on replay crew, say hi in the chat or in the comments. Let me know your opinions. I always like to hear them. I'm very active in my comment section. Subscribe if you haven't already. And those are all the things that you can do. So while all the people, all the best research, Schnitzel Ninja, and JFC, they have all posted this. The only reason I am using all the bests this time is because they have the call sheet in the beginning that I want to look at that I hadn't seen. All right. And away we go. Oh, some things about this that I wanted to share. So this police call was a request for a wellness check, and it was in response to a Medium blog that Laura Owens posted. And so she discussed her declining health related to the eating disorder and made statements about dying, unaliving. It and all that. And so body cam, the one is the officer's contact with the reporting party. And then the second body cam is the officers approaching the residence. So it is a chronological look at it. At least they laid eyes on Laura this time. And I don't say that so that we have body cam footage. I say that because if somebody is having a wellness check, don't just take the person at the door's word for it if they are not the person you're checking on. I don't care if it's their mother, their husband, their siblings, a child. I don't care. Lay eyes on that person, all right? But they pinned a comment that says, for important context, the Maricopa County Attorney's Office investigation report was not obtained by us until January 23rd, 2026. And that those findings are what ultimately led to Laura's original 7-count felony indictment. So we didn't have access to that even yet. We knew she had been indicted, but we didn't have that investigation report. And so we got the investigation report on January 23rd, 2026. And this was done January 14th, 2026. So you kind of know where we are. And it's crazy to think that that investigation report has been out there that long. So let's make this embiggened. The body camera of Laura and Jan is blurred. That is the way the body cam footage came in. So it is not a clear image of them. I mean, you get the idea and you can see who it is, but it's blurry and not clear picture. I'm sure that was done purposefully, probably at the request of the Owens, or maybe just because they know this, people are reporting on it. So now we will get into this.
This is Tracy.
Hi. I was wondering if I could call in a welfare check for someone that lives in Scottsdale, just so that you're aware.
Okay. So this is the CAD sheet that I was talking about. So January 14th, 2026, a person that lives in the pool house. Main house is also occupied. And so that was at about 3:30 in the afternoon. And so they go and do all that. But I just wanted y'all to be able to see this if you hadn't already.
I don't live.
Nope.
Okay, what's the address we need to go to?
So it is, apologies, I had everything pulled up and I exited out. You might be very familiar with it. It's
Okay, and is that a house or is there a unit number?
so it's a freestanding home, but the person lives in the pool house in the backyard.
Is the main house occupied?
Yes, it has her 2 elderly parents.
Okay, and who is it we're checking on?
Her name is Laura Owens.
So you said Owen?
Yes, Owen, S as in Sam.
Okay, and how old is Laura?
She's, don't know her exact date of birth, but I
Do you have a phone number for her?
I do not.
Okay. And what is her relationship to you?
So I don't know if you are personally familiar with her. I know she calls you guys all the time. She's currently facing like 14 felony charges. She had like this whole paternity scandal with the Bachelor Clayton Eckerd. I am literally one of the people that follows, I'm a true crime person that follows her court cases. She posted a Medium blog today for the public to read because apparently she has an eating disorder. It goes on for 23 pages talking about how she's going to die. She has a history of making suicidal statements. She has made suicidal, you guys have done wellness checks, I want to say in around, I don't even remember when it is now, like the last couple months, because a podcaster who follows the case, Dave Neal, they sent, someone sent him like an anonymous email that she had attempted suicide. So like you guys have been out for wellness checks before. There was an issue in like 2023 where the FBI actually called one in because she reported someone for something and said that she was borderline suicidal. So this is the thing. She writes a 35-page manifesto that's posted online talking about how she's going to drop dead any day. And if you want a link and there's a way for me to provide it to you, I can certainly link you to what she wrote.
Yeah, I can have the officer reach out to you. They have to have contact with you and then have the means to send a link. So get to review that. I'll have the officer contact you.
Okay, that's perfect.
What is your name?
So my name is
And last name? And what state are you in? Okay. And what is your callback phone number? Okay. All right. I've got the basics in there from what you've given me. So I'll get that over to the officer, have him review it. I'll have him give you a call.
okay. Does it come from like, will it say like Scottsdale Police or unknown number,
It'll
just so
likely
that I
show blocked
know?
or restricted. It's usually one of our patrol officers, and they usually call from a cell
Perfect.
phone. So yeah, it'll come in as unknown.
Perfect. Just so that, because you know, spam calls are fun nowadays. So that way,
Oh,
if
right.
it comes in blocked or something like that, I'll just answer it anyway.
Yeah, of course.
Okay, great. Thank you so much for your help.
Yeah, you're welcome.
All right. Bye-bye.
Bye-bye.
Okay, so that was the 911 call. This is going to be the officer contacting the person.
No injuries.
Hi, is this?
May I ask who's calling?
Yeah, Officer Dunn with Scottsdale Police. How are you?
Oh, thank God, because I took a chance and answered, but it was really weird because it said.
Yeah, no, that's okay. I mean, we use phone apps to make phone calls and such, and it just automatically generates a phone number from the same area code of the call we're making. But yeah, so you called in and asking us to check welfare on Laura.
Yes.
Can you?
Yes, it's a very bizarre situation.
Yeah, so fill me in. What's going on?
Okay, so here's the thing. I have followed this case. I don't know her personally. She knows of me. She's written people email complaints about me, but ultimately she has this history of making suicidal statements. It's usually manipulative, but you know, unfortunately, I used to be a social worker. Nobody wants to question anything like that because ultimately we want people to be safe.
Right.
So I follow this case, and today she posted a Medium blog online that's like 34 pages long, and I can send you a link to it if you want.
Sure.
But basically, she goes on for like 34 pages about how her eating disorder is so bad she can't control it and she's going to die. Okay. She talks about death multiple times. It's very fixated on death. In this particular article, she doesn't make any clear-cut suicidal statements, but you guys have been out to her home before because I can't remember when, but in recent-ish times, like I want to say in the past year, she had somebody had sent Dave Neal, a podcaster, an anonymous email that she had attempted suicide. You guys were out for that. There was another time she filed some kind of report with the FBI and said she was borderline suicidal, and you guys went out for that. So the fact that she has all these risk factors, she's indicted for 14 charges. She's got multiple court cases across state. Because I don't know how well you personally know this case. I'm sure your department knows a lot about her overall. There's probably officers that are like, oh yeah, I've talked to her, but I don't know how much you've ever actually gotten to tap in, but she's got a lot of risk factors. She doesn't have a lot of support. She does have this eating disorder. She lives with her parents, and her mom is going to the gym with her every day, and you can see in pictures that she posts online that she looks skeletal. So I really am just concerned for her safety. I'm concerned if this is a passive way of saying I'm just going to off myself. I don't know. I'm not in her head. But like I said, all the risk factors, all the stress, the fact that she's had bad bankruptcy hearings this week, it's just kind of it's concerning to me. It really just kind of, in my human heart, just kind of was something is not. I would rather someone go check on her and make sure she's safe than something happen.
No, I can appreciate that for sure. Yeah. I'm hearing you don't want that on your conscience, and you have got very good reasons, and you're outlining that with the explanation for sure. I personally don't have any contact with her, but I'm currently getting all kinds of messages with people that have.
Oh, goodness.
Okay.
I don't know if you have a way, but if you want, I can send you a link to the blog so that you can also read it and get your own perspective from it. Because obviously
That's interesting that she said she hadn't personally had contact with her, but she's getting a bunch of messages with others that have. So I guess maybe other officers were like, be prepared. Be prepared. Watch what you do, because they will file a complaint so fast. Hello, Dana.
someone that's followed this case, and I am, hoping she gets convicted because she has to stop doing this fraud stuff she's doing. So I may read it with a slanted bias. I'm open to that. I'm more than willing to send it to you so you have direct perspective, because I don't in any way want to make this out to be seem in some way like I'm trying to get her tripped up, if that makes sense.
Yeah, no, I can appreciate that. And let's go ahead and do that. Do you want to send it to my work cell phone number if I give you that, or email? What is easier for you to direct it to me, or send me the link?
Do you have an email? Because my phone gets weird about text messages sometimes. I live in the boonies, and for some reason, anyway.
No, yeah, that's absolutely fine. Can I? Are you ready to write it down, or do you need a minute? I'll give you my email, and I'll just have you send me that.
Yeah, I'm ready.
Okay, so it's my first initial.
Okay, I will get that link and I will get it sent to you.
Okay. All right. Well, I appreciate everything. I'm going to run over right now. I've got another partner that's on the way to meet me over there. So we're going to go and check her welfare right now. Okay.
Okay, great. Thank you so much.
You are so very welcome. You take care now.
All right. Bye-bye.
All right. Bye-bye.
Mother Pugger, she's probably just using her customer service voice. All right. So then we have this. Yeah, you would think you should take that stuff seriously, but, what's interesting is that here she says this stuff and she's not serious about it from what we've seen thus far. And then if you're watching the Clancy case, she was telling everybody, professionals, everybody, hey, I am. And everybody's like, nah, you're fine. So, you know.
Hi, how are you? Good. I'm looking for Laura. I understand she's not in trouble.
Okay.
I understand she stays in the pool house in the back.
Yeah, what's up?
So someone called. I guess she has
This
been.
isn't a welfare.
It is a welfare check.
Oh my God. Oh
So
my God.
something that got posted on a blog concerned someone that read it.
These people are idiots.
We are not the ones that wrote the blog. Your daughter is an idiot for posting shit while she's under indictment. If she didn't put out these statements, nothing would happen. Or if she just wrote about puppy dogs and rainbows, or if she just even said stuff about her situation and didn't put things in there to try to make people feel guilty for her or feel sorry for her or make people feel bad, nobody would be doing it. But what if someday she does decide to go with it? And we're like, you know what? You're right, Jan. You're right. These people are idiots. And we'd be like, you know what? We sent people to check on her multiple times. Not we sent them. Nobody sent them to do this, but concerned people out there. I don't know who. But there are people out there that are concerned for her. And they're going to be like, well, people tried to warn people all the time. And her mother was just like, they're so stupid. And she's like, hi. And you're like, so it shows that you're lying and manipulating.
Oh my God.
Now, I didn't take the time because it was a very long posting. So I'll be honest, I didn't read through all of it. It does look like she's, talking about being anorexic and her condition.
Because these people have gone after her like crazy.
Okay.
And so she posted it to say like, hey, back off.
Okay.
But hang on a second. I just don't
She
want my
didn't say
dog
back
to go. Do you want to come in?
Yeah, is that okay? Can we go to just check on her? Or
Let me bring her.
you want to bring her here?
Yeah,
Yeah, make you more comfortable.
I just
Okay.
don't want this guy. This guy's a little bit of an escape artist.
Oh no, we'll keep an eye on him then.
Yeah, I was gonna say you got handcuffs.
Get him. All right.
Break out of him. No,
He would. He's too skinny for that.
Yeah. Hang on. Let me just call her and have her
And
her
just
come out.
I just got to just chat with her really quick, and we'll get out of your hair.
Yeah.
Thank you. No worries.
Because she could write a blog that says back off, but she doesn't. She doesn't. She just screams victim. Hello, Micheller. But yeah, we don't know what people's intentions are. I mean, we have an idea of what Laura's are, but what if one day it's not just her doing it and all of this becomes too much, and it's not because of us, it's because of her actions, and that she's going to actually face some consequences. I don't want that to happen.
Unbelievable.
Nope, there's none. Back that off. They sound like they're having a grand old time in the house.
Hey,
Hi.
I'm so sorry they called. something
No,
in.
that's okay.
Yeah.
No, I mean, and
Yeah.
it sounds like we've been out before. So you
I'm so sorry that they called to waste your time, even though I tell people I'm going to do things to myself all the time and that I am doing things to myself and it's all their fault. But I'm sorry they waste your time. Don't put stuff out there. Keep your mouth shut. Because it makes it look like you're still playing games, Laura. Because the prosecutors have the blog. They will have this. They have it. Your defense attorneys will have it too. But, like, this shows that you're continuing your facade.
understand. We
Yes,
just got to
no,
come
I
and
know.
stop by
Yeah,
and
no,
check
I
on
totally-
you
I
and make
totally
sure
get it.
you're
No,
okay. And
This harassment group calls stuff in all the time. So
okay.
I'm
Now,
used to it.
and I've never met you. I'm sorry. Hi, I'm
Yes,
Kirsten.
I'm
Nice
Laura.
to meet you.
Nice to meet you.
All right. This harassment group, is this because I'm under like
Oh,
my background for this
Yeah.
call had something to do with an online like a blog or something, and something that was
Yes.
posted today,
yes.
and someone just
Where I
saying there
talked
was,
about having an eating disorder and
Yes.
how badly I want to live. So I don't know why they would.
Yeah.
Because what
You do not talk about how badly you want to live. Nowhere do you talk about how much you want to live. You tell us that it's going to be our fault if your nieces and nephews or whatever don't have you around anymore. That doesn't sound like somebody that wants to live. So, lying, as usual. And I love when they try to bring up the harassment group. They're like, well, the harassment, the online smear campaign. And they're like, well, I don't know about that, but I personally read the blog, myself, or I am personally going off of stuff that you submitted or that you have done, that worries, us, and we think it's something to look into as well. So, like, it just, that's the thing with the online harassment and smear people, because apparently we smear people with the truth, is there's evidence to back up the things that we are worried about or wondering about, and they have nothing to do with anything that we've done. It's stuff that they have done themselves. We didn't write a blog. You did. We didn't make up that you were going to do this. We didn't call in a fake thing. But you showing up, like Dana says, happy, shows that your words are meaningless.
what they have wanted to do in the past is they've called you guys out for welfare checks.
Mhm.
Then they go and request the video, the body cam.
Okay.
So then they post it online, and then they talk about how we look when we respond.
Yeah, how our family looks.
You
They
know,
make memes of us.
It is
Oh,
a waste of
okay.
police resources.
I'm not going to say never, but you know what I haven't seen with this? Anybody talking about their appearance in this video. We don't need to talk about that. There are other things to talk about. We talk about the words coming out of your mouths and how you spin things. But Laura looks to Jan as her mouthpiece too. Like Jan is the official spokesperson. So it's Jan's mouth and Laura's face for their businesses. That's a bad combination. But we've never called in one of these just because nothing was done. We're not like, you know what? I'm bored this Thursday, so I think I'm going to call them and just do this. I'm not going to have a reason to. I'm just going to be like, you know what? She had posted online and I really want some content. No. Anytime one has been called, it has been because of one, she contacted somebody that had somebody go out and do a wellness check. Or somebody else. I don't know that all of them have been a part of this JFC, whatever you want to call it, have done all these. It's never just because we want to.
Sources. It really, and I am so sorry that you guys are caught in the middle of it, you know.
That's
But
okay.
I mean, yeah. And they were saying, you said that they said something that you should be thrown in jail for being anorexic.
Yeah.
They did, yeah.
Who has
Okay.
said that?
So
Nobody has said that. You make crap up. Nobody said you should be thrown in jail because you're skinny or you have a supposed eating disorder. I don't know how you got yourself to your weight right now. I have no idea. I have some suspicions of certain things as to how and why and different things like that, but nobody says you need to go to jail because you're skinny.
really physically at the moment, you're not bleeding out and you're not needing medical attention, any intention of.
So on January 14th, 2026, she's not bleeding out anywhere. Which is good to know because sometimes she says she's bleeding.
Harming yourself, want to live,
Yes.
not upset with anyone else to the point where you feel like hurting someone else.
Not even close.
All right then.
No, you're good. No, thank you so much. I appreciate it. I'm
Alright.
sorry about that.
No, that's
Yeah.
okay. That's okay. I got the call, so I came out. Man, and just for your own peace of mind, I don't know necessarily what route they'll take, but no one asked me for the call for service number associated. The woman that I spoke to that called today to ask for the welfare check did not ask for the call for service number. So if somebody wants body camera footage, they're going to have some sort of
I
information
bet
to
they'll
get it.
somehow figure out how to get
I mean,
it.
they could,
Yeah.
but
Do you know who they were?
is the name.
She harasses me.
She has posted about Laura 20,000 times.
Okay.
Prove it. Prove where they've posted 20,000 times about you. And I don't like that the police are giving them this information. I hate this part. This part pisses me off. And it's not the first time they've given out some information like that because that's dangerous for the person doing this. And even if it wasn't this case, what if it was another case? And it's a mom sends a wellness check to go check on somebody's daughter. And the husband answers. And let's say, okay, the wife is fine currently. You know, maybe he went and untied her or something and had her cooperate. And he gets the name of the person that called and did this wellness check while he's in the midst of trying to do something to this person because it's a domestic violence relationship or something like that. And now the husband has the name of the person that called a wellness check. I'm not saying, I mean, you know what? I don't know. I don't know if Jan and them would go do anything with it. But I don't like that they're giving that information because that to me is it's not safe. Because who knows what they would go do to that person or have somebody go do. Or what any of their people would go do. We know there's somebody that's associated with that likes to dox people. So this part pisses me off that they got the name of the person. And I don't know if it was their real name, if it was their real first and last name. I don't know if it was the username. I don't know who it was. But I hate this.
20,000 posts about Laura. Laura has never met the woman.
Yes, she does. I just spoke with her briefly before I came over
She's
here.
literally insane. Yeah, she's
Okay.
she's absolutely a stalker. She's obsessed with me. So
Okay.
and she's not concerned about me at all. She wants body cam footage. They all just want body cam.
They want something. They feel like they have a community and that they have somehow bonded over their hatred of Laura. And Laura had gotten pregnant by a guy who was the Bachelor on TV.
Let's mention
And
that. Let's
so-
mention how prominent she is.
Then he decided that she wasn't really pregnant, even though she tested positive for a pregnancy in front of him and has medical records and all of that stuff proving that she was, and photographic
Yeah, but
evidence.
she's also been found to be a
She had
liar.
miscarriage.
Wasn't.
So then he went around
There's no
and
proof of that.
just tried to make him portray himself as a victim, that, oh, she wasn't really pregnant.
He has these
Oh,
bachelor
that's why
fans,
she's charged.
like hate me. That's
Okay,
So
so
yeah.
there's just
We are not Bachelor fans. Stop putting out that narrative. Like, y'all just this is the problem with y'all. Y'all just put out a bunch of garbage that you have nothing to back up anything you say. At least when we speak, we have the receipts to back up what we're saying. We're not pulling stuff out of our ass and talking about it. Most of us are not here because we were Bachelor fans, fans of Clayton, watched the show, watched his season. Many of us haven't watched his season. Maybe some have now, but no. And it's not necessarily about hating you. It's about hating your actions and what you've done, and that you need to take accountability for it, and you need to suffer the consequences of your actions. It has nothing to do with hating you. Do I dislike what you've done? Yeah. Could you change if you wanted to? Yep.
it's
just been yeah.
there's a whole lot of history and
Right.
background
Right.
here involved
Years.
in this. Okay,
Right,
okay.
Right. And he got Charlie Kirk. He didn't tell Charlie Kirk that he wanted Laura to have an abortion. But
yeah,
he
Mom.
told
I mean,
Charlie
Charlie
Kirk
know all the
there's
it's a 2.5 year. Yeah.
Let me name drop other celebrities, and let me bring up Charlie Kirk. That he knew Charlie Kirk because he talked to Charlie Kirk before he died. You know who also brought up Charlie Kirk? David. It's just, let me put all the big names to this. The Bachelor, Charlie Kirk, Gilgo Beach murders, P. Diddy, all of them. They're all connected.
That's all I need. So I mean, she's just crazy. So
Yeah.
Okay.
Yeah. But is there any way that you could maybe contact her and tell her that to make false reports is not?
yeah, because there's
They
nothing
make
else
false
I'm gonna kill
reports.
myself or anything. She had no reason. To be
No, and she didn't, when I asked her, because I always do that when I'm
Yeah.
on these kinds of calls, I ask like what statements were made or what was
Yeah.
it that you read.
Uh-huh.
And all that was articulated was the only comment she repeated was something reading that acknowledging the eating disorder may kill you.
Right.
And so, and honestly, I tried to start with a phone call to you instead of coming to your home because I thought, okay, everything that I'm hearing, I think I'm just going to give you a quick call instead of coming by.
Right.
I just couldn't get you on the phone.
Oh shoot, I am.
So you
sorry.
probably
I had
missed
the
a number
dog
with the
down
same
there.
area
Yeah.
code.
Okay.
I don't know. When I dial phone numbers from my app, it just automatically pops up with the same area code that your phone number
Oh.
has. A few moments ago.
Okay, that's what
I had gotten one too about 10 minutes ago. So
That I didn't try because
okay.
I actually did try to find information on you because that was the other thing
Yeah.
I thought.
Jen's like, well, I got a call too. Jan, that was a bill collector. Okay. That was a bill collector. Stop trying to make yourself, you're not Laura. Even though you probably pretend to be or allow her to pretend. Jan's like, I'm important too because I got a call. No, you didn't. That was a bill collector. They needed you to pay your bill. And if Laura has an iPhone, I forget if she has an iPhone or whatever. I have it to where I don't care what area code you're calling me from. If your number is not saved in my phone and it's an unknown number, it's booting you to voicemail. And unless you leave me a voicemail or text me or something, and then I'll be like, oh, okay, and I'll save it in my phone. Unless I'm told to expect a call, then I'll like turn that off, or I'll just answer those calls until I get the call that I'm expecting from a number that's not going to be saved in my phone. But that's probably what happened there. But Jan be like, I got a call too, ma'am. We didn't try to call you. No, and I think that just because somebody may not like Laura, that doesn't mean that a wellness check is unjustified. It's and yeah, there's so many blog posts. There's so many that it's amazing that we don't have a wellness check for all of them. I mean, if people were just calling to just call because we wanted footage, I mean, there are other ways to get footage. But it's just like, it's just so crazy. And she's like, well, can you tell her that making a false report, ma'am, it's not going to be considered a false report because she had a legitimate reason for calling, and the statements that you made are concerning. And if somebody read that, they might have the same concerns. Yep. Well, this was way before all that bankruptcy stuff. And I don't remember if she was under 14 at the time. I knew it was before we found out about the investigative report. But she had been indicted already, and we knew that. It's just to make sure that you're okay. Nobody cares about me in any of this. Okay, but we're making sure you're still alive. And you know what? If you had answered your phone, maybe this wouldn't be here. But why would they answer their phone? They have, I mean, one of the main reasons I don't want to talk to bill collectors. Most of them are all hospital bill collectors, but I want to talk to them. They don't want to answer their phones. Most people are like, I'm not answering that.
Well, maybe if I can call mom
Right.
Yeah.
instead.
Right.
And so because I couldn't get a hold of anyone by phone, that's why I
Then you had to
physically
come.
came to the
Yeah.
house. Now I have to come to the house. So that's the reason for me
Okay.
stopping by.
Yeah.
I tried to just resolve it and check on you via phone, but I
I'm
couldn't,
so
so
sorry.
I
I was
came
on
here.
top of that and I didn't. So
Yeah.
I'm sorry about that.
Yeah. Oh, I am really sorry. I mean, it's awful because we also think like, if we really need help, and we've called the Scottsdale Police Department before and said, hey, these people are doing this, but it's like, if we really needed help, would you guys be kind of like, well, it's a phony baloney thing. So.
Oh no, we'll come every time. Yes, we will.
All right. Okay. Okay. Well, we just, we feel bad about it.
Yeah.
Don't feel bad.
Yeah.
That's what I'm here for. Just do my job. Glad you're okay.
Yeah,
You've answered
definitely.
numerous
So
of your
I
dumb
have no
calls.
intention of,
About
I can't call her
Instagram
back
posts.
to ask your point. I don't want to call somebody back and say that they were making a false report. Because in her, like the way she explained it to me, and I'm just saying, this is what it was explained to me, was that based on that comment, there was some concern that maybe you needed some help or resources.
Right. No, what they wanted to do was harass and embarrass.
Because I do get that, and I get things like this all the time.
We don't
They're
need
like,
to
"Make me stop
embarrass
calling."
you.
I'm like,
You embarrass yourself.
Yeah, exactly.
everyone
Right.
needs to be able to
Right.
call the police,
Yeah,
and then we
Yeah,
get to
right.
filter through it.
Right.
Right.
So I've filtered through.
Right.
At this point, everything's good. I'm going to get out of your hair.
Okay,
Right,
thank you so
right.
much.
And
No.
they talk online about how bored they are if there's nothing going on. So
No.
they, like, create.
No, we do not talk about how bored we are online if there is nothing going on. Most of us cover other things. You're not the only thing that people have going on. Well, if we called the police, no, they would still come. God, you are so dumb. We're bored. We have no content. So let's do that. No, nobody's lacking for content.
Drama, yeah.
Okay.
We don't need to
If
create drama.
you
Y'all
ever,
do
and
enough of
I'm
that.
assuming I wasn't going to read through everything that was posted. If you ever needed any kind of resource, I'm just going to give you this card. I don't know if you've ever talked to anyone with a.
Oh, I mean, I have a counselor, but I mean, not a psychiatrist, but you know.
No, that's
We're right
very
now. I
nice.
really
That's very
Just
nice.
wanted you to have it. I mean,
No, it's
just
very
know that we've
She's not a
got
psychiatrist.
civilian employees.
Your
they're
counselor is
social
not a
workers.
psychiatrist.
They've got a tons of resources in our community for anyone that feels that they might need some assistance with something. I always pass those out or direct people to talk to them because they're so much more knowledgeable about things that are available in the community to our citizens.
Right.
All right, my
No,
dear.
I really appreciate that. Thank
Yeah.
you so much.
All right.
Great of you.
Yeah,
Okay,
take
have a great-
care.
have a great night.
Thank
so
you.
much. Take care. Stay safe.
Thank you.
Notice she didn't ask them to see their car or anything like that. Like she's done in other videos. I need to see your car. I don't even know if you're the real police. It's just. Okay. So Laura might have been dealing with hers because I think Jan and then had dropped hers. But yeah, I mean, she was doing a lot of stuff. It's just so crazy. So, make sure you subscribe to All the Best. Make sure you subscribe to Schnitzel Ninja. So that y'all can watch those without anybody yapping over them as well. So you can hear it. And then when people yap over it, you can put your 2 cents in and yap when we yap. Because it's just absolutely crazy. I wasn't expecting that. And I'm glad I saw the date because when it first came out, I was like, did somebody seriously just call one of these in thinking it was more recent? And what I don't want people to do is, hey, Miss Roslyn, is I don't want people just to call and harass. Because we don't want it to be the way that they are saying it is. And it's not. But that was my fear. And then I was like, oh, because I was like, well, she hadn't written anything in a long time. And which a long time is what, 8 months now. So I'm like, okay, let's people don't need to be doing that, which nobody is. But I was like, okay, this is back in January when she made that random one. And we were all like, why are you making a blog post? When one, you have your Justice for Laura website. And then 2, you are under indictment, ma'am, and anything you say can and will be used against you. And I think she made that when she was in between lawyers. Jan can't even see in front of her feet. She definitely can't be a psychic. She can't see. She can't see anything. Yeah, you know what was also not on bankruptcies? How that shit was paid for. Let me see. Yeah, justice for Laura is still up. Nothing has been, of course, done on it. So, but it's still active. It doesn't give me like a, I don't know how they're paying for it, if they paid for it for a year or what, because I can't even see. Like sometimes down at the bottom of the pages, it'll tell you that. But it doesn't. They have a donate button though. They do have that. Nope, none of that was on there. I didn't think about that either until you just mentioned it. Because that's stuff that they have to pay. Here. See, donate button. I wonder if anybody has donated there. Because what does that go to? Ways to support. Your contributions will enable us to continue our efforts in advocating for justice for Laura Owens. Thank you for standing with us. Wait a minute. Oh, it says stay informed. Okay. So it doesn't actually have a place that you can click and go. Okay. So it's got a donate button, but it's not active. So that's good to know. It just takes me to that page I just showed you. And then there's nothing clickable after that. It just says stay tuned. Or spread the word, stay informed. Nothing clickable. Oh, wait. I could be wrong. I could be wrong. Hold on. No, that just took me back to another place. No. So there's no donate active thing where you can go put in your credit card or anything like that. So I just discovered that. Thank you, Rosalind, for that, because I haven't even paid attention to it. Get off of that website now. All right. Now we need to bring up let me see here, because I think I might. What's interesting is that in the minute entry for this dismissal of the bankruptcy, I don't know how to zoom in on this. It never lets me zoom. What does this one do? Okay. Ah, okay. What happened? What's interesting is on the call, I'm sorry if I can't read this. On the call, you know, the judge found the same things as Miss Giamo did about, you know, there was bad faith, and different things like that, and that they made misstatements and different things like that. But in the minute entry order, it just states that demonstrates that the debtors are unable to satisfy the obligations imposed under Chapter 11, and there is no reasonable likelihood of a successful reorganization within a reasonable period of time. The court further finds that dismissal rather than conversion is the best interest of the creditors and the estate. The record reflects significant failures to comply with Chapter 11 requirements and demonstrates that dismissal without prejudice would not adequately protect the integrity of the bankruptcy process. The court further notes that debtors have filed multiple bankruptcy cases. A period restraining the debtors from seeking further relief in bankruptcy is appropriate in light of multiple errors, misstatements, and possible misrepresentations reflected in the record. The court finds and concludes that a 2-year bar to the filing a new bankruptcy case will further the purpose of 11 USC 105 and 349A by protecting bankruptcy process and discouraging abusive or premature filings. During the 2-year period, GoFundMe claimants and other creditors may be able to prosecute any claims and causes of action against the debtors in the state court. Other actions against the debtors may also proceed. The bar is appropriately tailored to the circumstances, and the debtors have stipulated and agreed on the record to its imposition. For those reasons, the debtors' motion for voluntarily dismissing is granted, but it adopts the U.S. trustee's recommendation for a 2-year refiling bar date. So it is dismissed with prejudice for those 2 years. And then after 2 years, they can attempt to do it again if they wanted to. You wanted to do your own version of Her Hits Dogs? Thank you, Miss Roslyn, for the jewels. Hello, Miss Wings. We've just gone over we went over the body cam footage of the wellness check. And I was just looking to see this order where it talks about, I had thought it didn't mention the misstatements and them being liars, basically, in the hearings. Let me see here. Okay, and I'm actually going to speed this up. We'll listen to it just because it's funny. All right. We are going to move, stop screen share. Now we're going to go to Schnitzel Ninjas so that we can give her the view as well. since we gave all the best view earlier. So make sure we give them to our peoples. And I have it at 1.25. I would listen to it faster, but I don't know if other people can.
In the case 26-05144, Elizabeth Naylor and Ronald Owens.
Good afternoon. I'll take the appearances in the Owens and Naylor matter. Let's start first in the courtroom.
Thank you. Good afternoon, Your Honor. Jennifer G. I'm on behalf of the U.S. trustee.
Thank you. Good afternoon. And I'll take appearances from Mr. Owens and Ms. Naylor.
Yes, good afternoon, Your Honor. I am Elizabeth Ann Naylor, appearing pro se.
Elizabeth Ann Naylor, Jan Black,
And
Owens.
I am Ronald
well.
Stephen Owens, also participating pro se.
Okay, thank you. Good afternoon.
Sure.
All right, let's go ahead and get started. We've got two matters on calendar. This is the time set for continued Chapter 11 status conference, as well as a hearing on the debtor's motion to dismiss this voluntary Chapter 11 case. I'm aware of the parties' filings, but let me turn it over to you to see how we wish to proceed. Shall I start with you, Ms. Jamo?
Thank you, Your Honor. Yes. So just to remind Your Honor, the debtors had filed a motion to dismiss. And at the last hearing at which that was raised, Your Honor wisely pointed out that we needed to collect some documents and do more investigating before the case should be dismissed. I'm very glad that Your Honor had required that. We did receive what was called an accounting of the GoFundMe funds, and we received many bank statements that I was able to review. As the U.S. trustee laid out in her recent supplemental response to the motion to dismiss, there was some disturbing material that came out through our investigation. And for that reason, the U.S. trustee's position is that there's definitely bad faith here and the case should be either converted or dismissed. And also, as laid out in our supplemental response, we think that based on our analysis of the assets, that dismissal with a 2-year bar to refiling would be the wiser choice because there does not appear to be really any sure collectible assets in this case.
All right. Thank you. I did have an opportunity to review your supplemental response at docket number 89.
She is right about there was some disturbing things uncovered during that time period. It was complete chaos.
Tell me more about why the recommendation is for a 2-year bar to refiling. Often we use a shorter period if there's a secured creditor looking to foreclose, or a longer period if we're looking for litigation to conclude. 2 years is pretty lengthy. So could you give me some additional information about that long period? And also, it's my understanding that Ms. Naylor and Mr. Owens have agreed to that period. Is that correct?
Yes, Your Honor. Yes, I should have pointed that out. Yes, Ms. Naylor and Mr. Owens, in correspondence with me, have indicated that they were willing to have the case dismissed with a 2-year bar to refiling. So the reason that we're asking for 2 years is because this case was filed in bad faith, we need to have a sufficient deterrent to prevent another repeat filing that would, again, interrupt creditors from pursuing their rights. 2 years, just weighing it, seems like an adequate amount of time to allow a foreclosure of the home to follow through if that's what's going to happen. I understand that there was a foreclosure set first in May, then I think it was reset to September. Now I believe it's reset to November. Ms. Naylor would know that information better. I don't know what is going on with that process, but it seems to me that is the driving force behind these bankruptcies is the house, right? So I think that we absolutely need to give the creditor sufficient time to foreclose on the house if that's what's going to happen. I think 1 year might not necessarily do it, especially if they're trying to work something out. And so I feel like it's actually to the benefit of the debtors to have it be 2 years. So
wait, did you just say it would be to the benefit of the debtors to be 2 years?
Well, yeah, because maybe that gives because if there's that much leeway given to the mortgagee to foreclose on the property, maybe they'll be a little bit more willing to spend some time trying to work something out with them.
Oh, I see. So should the mortgage company have additional time during which
that was an amazing way for Miss Giamo to spin it. I think it's for the benefit of the creditors. It's actually in their favor. I don't think they view it. I mean, they have to view it that way because they want it dismissed themselves. But they're like, you know what? We'll agree to any time. Just make the bleeding stop, please. Just please stop asking us questions and digging into us. Don't bring shit to court. Y'all knew people dug into you, and when you bring things to court, and you decided to do this multiple times.
Ms. Naylor and Mr. Owens cannot file bankruptcy, they may be willing to enter into negotiations during that elongated period.
Right. Exactly.
I understand. Thank you.
So there's that. And also there were 2 lawsuits against the debtors that those can proceed. And I think that based on the information that we discovered and laid out in our supplemental response, there are potential claims, I believe, by GoFundMe Inc. or donors. We definitely need to make sure that there's sufficient amount of time to allow those parties to pursue any rights if they choose. I mean, I have no involvement in that, but just based on my own investigation. So I think 2 years gives an adequate amount of time and is proportionate to the bad faith that we've seen here. And it gives an adequate amount of time to allow creditors to pursue their rights in state court, which is really what we want, right? That's the best interest of the creditors. And yet it doesn't completely foreclose the debtors from refiling should the need arise later, but there's a sufficient buffer with a 2-year bar so that creditors won't be harmed yet again.
Okay. Thank you for explaining that.
Wouldn't be harmed.
One reason I had asked is just because there was the pending foreclosure sale. The court previously declined to extend the stay.
Yes.
And so it seemed that the mortgage company could move forward. Plus, under Arizona statutes, they could foreclose within 90 days anyway. So it just seemed like a long period. I hadn't really considered the idea that a longer period would actually motivate the mortgage company to engage in negotiations. Have you seen that happen before?
No, but I don't know why the mortgagee is continuing to move out the foreclosure date. So I'm assuming that they're working with them. That's all. I really don't know. I mean, I've tried to reach out to them and they've not really been very responsive to me, to the banks. So, that's just one factor, but I do believe that we should have sufficient time to allow creditors, not just the creditors that were listed in the schedule, but other potential claimants that I mentioned in our supplemental response to pursue claims against these debtors without a bad faith bankruptcy filing.
Okay. Another area of inquiry, and you did address it in your supplemental response, was just whether conversion would yield any distribution. I read what you wrote, and I certainly appreciate that trustees are loath to have cases where we have animals that need care and food, et cetera. It ends up costing them money as opposed to yielding benefits for creditors. So I certainly understand the reasoning of the U.S. trustee there. Is there anything else you want to tell me, not necessarily specifically with animals, but any of the other assets in the the opportunities for recovery?
Well, Your Honor, I should mention to you that while the case was in a Chapter 13, there was a short time during which these debtors' case overlapped with the filing of a Chapter 7 case by the debtor's daughter, Laura Owens. And the attorney representing the Chapter 7 trustee in the Laura Owens case was Terry Dake. And I know that he was very actively looking into potential assets. And if you recall, there are some businesses that are co-owned by the daughter and either Miss Naylor alone or Miss Naylor and Mr. Owens with the daughter. And I did reach out to him to ask him what his professional opinion was as to whether the preferences made to the daughters is something that he looked into and whether there was any assets that he could conceive of either in the Chapter 13 case or in the Chapter 7. And it was his opinion just to me, in an informal discussion about it, that this did not seem like a good case for conversion. So we did factor that in. I didn't put it in the pleadings because it wasn't a real formal discussion. It was just something that I had run by him because of his familiarity with the case. But I did agree with his assessment based on.
What's interesting is if they were honest, their debts are really, really high, but I wonder if they were actually honest, if it might be a case for it. But because they hide so much and they move stuff around, that they can't. And it was a good point, and that was interesting to learn that getting the horses are not going to be worth the hassle and even the little bit of value that they have. I mean, they are older horses, but I didn't think about the trustees and them having to take care of them. I didn't know what happened with them if they did that, but I didn't think about them having to pay for that if they did take it away. So it's just the property needs to be taken away. And it's their own doing and nobody else's. Not the smear campaign's fault that you spent your money the way you did.
on my own analysis of all of the assets that are disclosed.
Okay, thank you for that additional information. And I do recall at prior hearing, you had mentioned Mr. Dake was involved in this case in some respect. So now I understand it's with the debtor's daughter.
Yes.
Okay.
Yes.
All right. What else do you want to tell me?
Your Honor, I think we just pretty much laid it out there. We think that there's definitely concerns, but in light of the financial situation, conversion would not make sense. It would be really a burden, I think, to any Chapter 7 trustee to ask them to take on such a case. So I do think that dismissal with a 2-year bar is the only way to handle it because of the bad faith. I do think there was a lot of bad faith, and that because of that, that's why we should have a little bit of a longer bar on refiling, because this is one of the worst I've seen in terms of misstatements, misrepresentations, and I would ask that that's what Your Honor do, especially in light of the fact that the debtors are agreeable to the 2-year bar.
All right. Thank you, Ms. Yamo.
Thank you.
All right. I note that there are.
And they deal with tons of bankruptcy cases with people that probably have way more money, probably have way more debt, but just the absolute nonsense in this is one of the worst she's ever seen. It's just complete fuckery. There are no facts, just fuckery. EDB would be having none of this.
Number of individuals who are appearing by Zoom. I'm wondering if there's anyone present who wishes to be heard before I return to Ms. Naylor and Mr. Owens. All right, hearing no one speak, I'm going to go ahead and turn to you, Ms. Naylor and Mr. Owens. What do you want to advise the court at this time?
That we have reviewed the trustee's supplemental response. We agree with the final recommendation to dismiss the case with a 2-year bar, but we would like to state respectfully for the record that we dispute any insinuation of any sort of fraudulent intent or bad faith. As pro se debtors, the Chapter 11 reporting rules were very complex for us, and any omissions or anything like that were honest, unintentional mistakes that were due to our lack of counsel, and we feel we cooperated fully and provided anything, any of the bank statements for 18 months, anything that we could to ensure total transparency.
Okay, so what you're, tell me about the 2-year bar date refiling. What is your position with respect? It was represented in the record that there was a stipulation and agreement to that period.
We had informal discussions with regard to that, and we had told the trustee that we were willing to go with a 2-year bar. I mean, frankly, we hope we are never, ever, ever in this situation again. And as we had explained before, we are trying to explore what options would be available for us to modify the mortgage and to come to agreements with the other creditors to resolve this outside of bankruptcy.
Okay. Are you engaging with your mortgage company or others in terms of in an effort to resolve those outstanding claims?
Yes, and we had, well, as far as the mortgage is concerned, we very much appreciated your suggestion that we work through the, I believe it's the MMM program through the bankruptcy court. And when we explored that, it appears that that would only come into play while we were actively in bankruptcy, and that once the case would be dismissed, that entire process would go away. So we have been trying to work through correspondence with the mortgage company, and we have again been told that in response to our latest communication with them, our latest letter with them, with the latest correspondence, that they will respond to us within 30 days. So perhaps that's why they maybe have moved out the foreclosure date more. But we are certainly wanting to work behind, the scenes out, I guess, outside of bankruptcy court with them to resolve this.
Okay.
July,
very good. I wish you good luck in that regard.
Thank you. And thank you again for your recommendation on going through the mediation program in the court. We really wanted to work with that, but it just looks like that ends when the bankruptcy would be dismissed.
Because I kind of wanted them to have
what else do you want to tell me?
Laura have to stay.
Just that I think regarding the GoFundMe campaign, we wanted to stress that there were no promises that were ever made to the donors, and that this was an effort that was the culmination of my husband's 5 decades.
Well, then maybe you should go look at Bacon stream that her and Big Tiff did, where they go through the comments and people are talking about all the medical stuff Because if you look at the comments that people put with their donations, it seems like a lot of those people were misled. We've been nothing but transparency. No. You try to act like you're dumb, but y'all want to harp and put your accolades out there. Hall of Fame radio person, Peabody award-winning journalist who apparently sucks at research because she can't figure shit out for anything. And, podcast, all this stuff. And y'all just want to play dumb. Nobody's buying it. I mean, if y'all were actually truly just dodo birds, then maybe it would be one thing. But the part that pisses me off is I hate when people that actually have knowledge, that actually have the capabilities to do things, try to play stupid. I don't like playing stupid. That's when your stupidity thing is a choice. I mean, hell, you'll have AI that could have helped you out. And it's fun. We needed competent counsel. I thought y'all were BFF with somebody that y'all thought was competent. I mean, he couldn't be your counsel for this, but I mean, he could be your Jiminy Cricket.
Decades on the air, and he and our family were very, very deeply touched by the outpouring of support from his listeners, who have truly become like an extended family to us over the last decade. So this was an appeal that was needed for housing and food and transportation and those kinds of things, and we were just very, very grateful for those contributions.
All right, thank you. Anything further?
Not for me.
Okay. Mr. Owens, did you say something, sir?
No, I said not off the top of my head.
Okay. All right. Thank you. Let me turn back to Ms. Jamo. Anything further, ma'am?
No, Your Honor, I don't think it's necessary for the U.S. trustee to get into a back and forth with the Owens about the GoFundMe funds. Our pleadings speak for themselves, and it's not an issue that is going to be resolved here in any event. So we'll just leave it at that.
Okay. Let me ask you this. With respect to a dismissal, is the court's signed minute entry sufficient, or will your office wish to upload a formal order?
I think the court's minute entry would be fine. I don't want to have to deal with having to go back and forth and try to make sure that we're on the same page. I mean, especially because we have Ms. Naylor and Mr. Owens here on the record. You're seeing them here, I'm seeing them here, and it's clear that they're voluntarily agreeing to this. I would be comfortable with a minute entry of dismissal saying that there's it's a 2-year bar of refiling. Although I guess I wonder if we do need an order on the record so that if another case is filed, there's something more clear on the record.
The clerk's office should be able to pick up from the minute entry what we call an exception, and so it would be noted so that if another case is filed, it would trigger personal or direct review. Let me check with Ms. Hall and make sure I'm not mistaken in my understanding, but I think that's accurate.
Correct, Judge, and it would be in the ordering paragraph as well.
Okay. Right. So the minute entry will suffice. Okay. For a bar date.
Perfect.
Okay, that works. So nothing else. And so Ms. Naylor and Mr. Owens, just so you're clear, I was just asking Ms. Jamo about the form of order that the court will issue. Generally, we issue a minute entry after every hearing, and I'm happy to sign that minute entry, and that will be the formal order of dismissal. And I was asking whether Ms. Jamo's office would prefer to have a specific form of order of dismissal. She's concluded, and I agree that that's not necessary. I'm just giving you the courtesy of asking whether for some reason you would like that.
No.
Okay. All right, then. I'm prepared to make a ruling. Thank you, everyone. All right. So the matter before the court today is the debtor's motion to dismiss their voluntary Chapter 11 case. The debtors filed this motion, and afterward, the debtors and the United States Trustee's Office have come to an agreement for dismissal of this case with prejudice, and they have agreed to dismiss with prejudice with a bar to refiling this case or any bankruptcy case for a period of 2 years. I've reviewed the motion. I've considered the parties' stipulation, the record in this case, and whatever arguments have been made by the parties. The court does find and conclude that cause exists under the United States Bankruptcy Code, Section 1112B, to dismiss this case. The record does demonstrate that the debtors have been unable to satisfy the obligations imposed under Chapter 11 and upon Chapter 11 debtors. And it's also clear that there's no reasonable likelihood that this case can proceed to a successful reorganization within a reasonable period of time. The court further finds that dismissal rather than conversion is in the best interest of the creditors and the estate. I've considered the scope and the nature of assets and the potential for transfers that could be avoided or other claims, and it appears that that would be very difficult and costly for any Chapter 7 trustee to undertake. The remaining question is the scope of any prejudice to refiling. Although the parties have stipulated to a 2-year refiling bar, I believe it's incumbent upon the court to independently determine whether that requested relief is warranted under the Bankruptcy Code and the facts of the case. In particular, since we haven't had an evidentiary hearing. A dismissal with prejudice and a prohibition on refiling constitute extraordinary relief. And generally, the court's rule is that such a bar should extend no further than necessary to address the conduct that has been presented to the court. So again, I do find that cause exists to impose a refiling bar. The record reflects significant failure to comply with the requirements of Chapter 11 and demonstrates that dismissal without prejudice would not adequately protect the integrity of the bankruptcy process. Accordingly, a period during which debtors may not seek relief in bankruptcy is appropriate. The court is also persuaded by the multiple errors, the misstatements, and even possible misrepresentations that the present record does justify a 2-year prohibition on refiling. The court concludes that a 2-year bar will accomplish the purposes of 11 U.S.C. Section 105A and 349A. A 2-year refiling bar adequately protects the bankruptcy process, discourages abusive or premature refilings, and is appropriately tailored to the circumstances of this case. In particular, because the debtors have consented to that 2-year bar. And Ms. Giamo points out an unusual and perhaps novel consideration the court had not previously considered, which is that with more time provided to the mortgage company, perhaps the parties can enter into an agreement or arrangement that meets all the parties' needs with respect to the real property. So for these reasons, the debtor's motion to dismiss is granted. This Chapter 11 case is dismissed under 11 U.S.C. Section 1112B. The dismissal is with prejudice to the filing of any bankruptcy petition by either debtor under any chapter of the Bankruptcy Code for a period of 2 years from the date of the entry of the dismissal order, which shall be the minute entry that will emanate from this hearing. I'm not expecting any additional form of order. Rather, as soon as this minute entry is filed, the case will be dismissed, and that will be the end of the matter. And with that, I believe everything that we were here for today has been considered and concluded. Is there anything else we need to discuss, Mr. Owens and Ms. Naylor?
Nothing.
No, just thank you very much for allowing us to appear via Zoom with the heat today. It's a lot more comfortable for my husband and for me. So thank you.
All right. Well, you're welcome and good luck. Ms. Giamo, anything further, ma'am?
Nothing further from the U.S. trustee. Thank you very much, Your Honor.
All right. With that, then we are adjourned. Thank you, everyone. Good luck.
Thank you.
Thank you.
And that is the end of that chapter. End of that chapter. So many chapters have started and ended. But how many pages are left in this book? So many pages. They do not excel at everything like Sarah Boone. You know, if only they could be Sarah Boone and excel at everything that they do, they would be set. Because I like that Miss Giamo was like, you know what? Our brief speaks for itself. I am not going to get into a back and forth with them about their clearly ridiculous statements about the GoFundMe crap. Sarah Boone's something was denied. I know some body cam footage, or not body cam, some jail phone house calls have come out about the dude that she's made her power of attorney. Those are pretty funny because nobody likes her. Oh, you know what? I don't think I have that one. That was one I needed to get, is deny sit down. Oh, there's so many jail phone calls. AG Tactical goes over them, but if you want to just listen to them yourself, you can go to prison. Phone calls from prison. They have them. Okay. Now we get to everybody's favorite dingleberry. Where is... There we go. There should be no audio for this. Let's see if there's a better view for this. No. Yeah. There we go. No, nothing recent. Her appeal may have been denied. Or they put her, they filed their appeal finally or something like that. I don't know. Larry, did a video on it. I believe EDB did as well. All right, so we're going to go through all these as case citations, table of contents, all that, face page. Respondent, State Bar of Arizona's response to petitioner's petition for special action. The State Bar of Arizona by undersigned Bar Council submits this response to the petition for special action appellate petition. Based on the arguments set forth below, the court should decline jurisdiction over this special action because, on balance, the factors for declining jurisdiction set forth in Rule 12 Arizona Rules of Procedure Special Action No, that's a good question, Dana. And I know that the people have said they're waiting for the judge to rule. But I don't know if the judge is going to rule on this augmenting the record thing. And so that's my only thing is, what if she doesn't ever rule on it? Because she didn't rule on it the first time, granted things or whatever, and then she submitted the second one and it still hasn't been ruled on. And I don't know if she has to. So that's what I'm curious about. And if so, are they waiting for Mike's response? And then, she has days. I don't know what the deal is with that, because my thing is I don't know that the judge needs to rule on the augmenting the record, or if she has to, or if it's past the time for her to be able to rule on those things, or what the deal is. I wish I knew more about that. Because, is this ever going to go forward? I don't know. Something needs to happen. Well, oh, everybody say hi to Ruse. That's my son. Thank you, Ruse, for the 2 jewels. I can pay those back to you. All right. So footnote 1. Nope, I just went past it. All rules identified in the response are to the rules of procedure for special action unless otherwise noted. Okay, good to know. But outweigh the factors for accepting jurisdiction. The petition raises primarily fact-specific issues decided in interlocutory rulings that are not and could not be case dispositive, i.e., some allegations of misconduct have not yet been adjudicated. And petitioner David Gingras, Mr. Gingras, Mr. Dingus, Dingleberry, Gingerbread, whatever you want to call him, has equally plain, speedy, and adequate remedy by appeal following a hearing on the merits of the allegations not yet addressed by the PDJ, Judge Vandenberg. Procedural posture of the case: the State Bar of Arizona filed a one-count complaint against Mr. Gingras on February 17, 2026, which included multiple allegations of misconduct. Which, that's interesting. When they put that, oh, he's not in school. He's an adult. Both of my kids are adult. He just works. Oh, he is working on I know he's working on something. He's getting a license and stuff. So he has been doing things like that. He is working on getting a license right now for his work and career. All right. So it was interesting to me that the State Bar said they filed a one-count complaint, because I thought it was like multiple counts, but it's actually just a one-count complaint with just multiple allegations and like in their totality. So I was like, oh, okay, that makes sense, because it did seem like a multiple count thing. Violation of a court order, efforts to preclude a potential witness from testifying at a court hearing, making disparaging comments about a judge and members of the public, meritless claims, false information in an affidavit, and non-meritorious appeal. So let's see. Gingras filed an answer on February 17, 2026. Based on concerns expressed by the PDJ, an amended complaint was filed on February 25th, 2026. And Gingras filed a respondent's amended answer on March 6, 2026. On March 9, 2026, the State Bar filed a motion for partial judgment on the pleadings. Then March 18th, Gingras filed a response to the State Bar's motion for partial judgment on the pleadings. March 23rd, 2026, reply to State Bar's motion for judgment on the pleadings. Moving to April 14th of this year, Gingras filed motion to dismiss and alternatively motion for summary judgment. And that was based on Arizona's anti-SLAPP statute. The State Bar filed a motion to strike that motion to dismiss on April 20th. Then 10 days later, on April 30th, 2026, the presiding disciplinary judge entered an order directing the parties to simultaneously submit briefs addressing whether the court's supremacy clause precludes this anti-SLAPP legislation, application, and disciplinary proceedings. And then on April 15th, lovely tax day, 2026, both the State Bar and Mr. Gingras filed their briefs. May 20th, 2026, Gingras filed a response to the State Bar's brief, reapplicability of ARS 12-751 to lawyer discipline proceedings. And then the footnote references to Mr. Gingras's exhibits that are identified as petitioner exhibits, while references to the State Bar's exhibits are identified as SB exhibits. On June 22nd, 2026, the PDJ entered an order denying Mr. Gingras' motion to dismiss based on Gingras' failure to demonstrate that the anti-SLAPP statute does not unduly hamper the court's authority over the practice of law in Arizona, noting that in an absence of such a showing, she is unable to determine how to apply the statute in a manner consistent with the court's rules regarding attorney discipline. On July 22nd, 2026, Mr. Gingras filed his petition for special action appellate. This is the state bar's response to that petition. Let's see. Yeah, I think that is when we're used to looking at like criminal stuff like that, those counts. Okay, by the way, reading. We should have an answer soon. Texas packet in the Maricini case. Yes, let us know what you find out, please. I am sorry. You have to read. All right. Mr. Gingras, the issues properly before this court. Gingras, through counsel, identified 4 issues in his petition for special action. Yeah, the dates haven't made sense to me for a little bit. Attorneys, I think it's supposed to say most attorneys surrender, but it says must. Or 1, must attorneys surrender their First Amendment and Arizona free speech rights by becoming members of the Arizona bar. 2, do Arizona attorneys retain the same First Amendment and Arizona constitutional protections as other citizens? And if so, did the state bar establish that petitioner speech falls within a recognized exception permitting discipline? 3, did the presiding disciplinary judge err by granting judgment on the pleadings when the material facts were disputed and by applying an erroneous legal conclusion that the First Amendment and Arizona constitutional protections for speech do not apply to lawyers? And 4, does Arizona's newly expanded anti-SLAPP law, ARS 12751, apply in attorney disciplinary proceedings? And if so, does it unduly hamper this court's authority to regulate the practice of law in Arizona and therefore violate separation of powers principle? The footnote says the issue of citizens' constitutional rights is not addressed in this case. No. And the way he tried to spin that, he acts like because he's like, well, just because you become an attorney, like you just lose all your free speech rights. And it's like, you know damn well that's not what was being said. None of that was being said. But that's how he's like trying to blow it up, that he just can't say anything because he agreed to be a lawyer with the Arizona bar. And that's not at all what anybody is saying. But of course he exaggerates. That's what I'm saying is I thought she was supposed to file it. Somebody said she had till another date. And then she still hasn't filed it, but she's waiting to file it as well because of certain things. I don't know. This is why she needs to be consulting with an attorney. Even if they're not her attorney on that case, like, I don't know why she couldn't just ask a legal question. But yeah, the end of June, she asked for like a 30-day continuance, and the judge said that she would agree to another extension, making it the end of July. And that was July 30th or July 31st. And then there wasn't going to be any more extensions. And then nothing was filed. But somebody told me it's because she's not late in filing it because she's waiting on something, which I don't know. Something I just don't know. Nobody's spoken about it. Omar is not the appeals person dealing with this. And so, and Omar hasn't said anything about that. "27th of this month?" Or that it was due the 27th of July. 27th of June. I don't know. She asked for an extension and then she got another extension. She's asked for multiple extensions. And I was like, you're supposed to turn in this. Her trial was supposed to go forward. The house was supposed to be foreclosed all on those last few days of July. Right. She got that 60-day extension and then she asked for one more. Because there was another one somewhere. Okay, back to this. That's just the question I have. I don't know what will happen with that. But when it does, we'll bring it to you, of course. So the State Bar contends that the issues identified by Mr. Gingras do not fairly and accurately identify the issues this case actually presents. Mr. Gingras' first and second issues are significantly overbroad, and if answered, would not resolve any issue in this case. Mr. Gingras' third issue lacks specificity. Okay, so let me see. If they answered 1 and 2. So if the special action people determined, must an attorney surrender their First Amendment and Arizona free speech rights by becoming a member of the bar? If they say no, that still doesn't answer this question. If they say, do Arizona attorneys retain the same First Amendment and Arizona constitutional protections as other citizens? And if so, did the State Bar establish that petitioner speech falls within recognized exception permitting discipline? If they say yes, or if they say no, that doesn't fully do everything. The case actually presents the following issues. 1, should the court accept jurisdiction to review the PDJ's interlocutory ruling granting partial judgment on the pleadings where a reversal would not result in judgment in Mr. Gingras' favor, but a remand for additional fact-finding? 2, should the court accept jurisdiction to review the PDJ's interlocutory ruling denying Mr. Gingras' motion to dismiss based on Arizona's anti-SLAPP statute? If the court accepts the special action jurisdiction, the issues then become: 1, whether the PDJ properly granted in part the State Bar's motion for partial judgments on the pleadings, finding that Mr. Gingras violated Rules 41B3 and 7, Rule 42, specifically ER 4.4A, ER 8.2A, and ER 8.4D by making disparaging comments about Maricopa County Superior Court Judge Mata, and 2, whether the PDJ properly concluded that Arizona's anti-SLAPP statute does not apply in lawyer disciplinary proceedings. Correct. They are only supposed to decide on things that have been decided. He can't just appeal to other things about other parts of his case. Disciplinary proceedings, absent evidence that the statute does not interfere with the court's constitutional authority to regulate the practice of law. Footnote 4, in denying Mr. Gingras' motion to dismiss, the PDJ stated the movement respondent Gingras has failed to demonstrate that the statute ARS 12751 does not unduly hamper the court's exercise of its constitutional authority regarding the practice of law in Arizona. Independent of such a showing, the PDJ has been unable to determine how to apply the statute in a manner consistent with the court's ruling regarding attorney discipline. Additional facts that are not included in the petition. Yeah, Gingras left out a lot of dang facts in his petition. I'll tell you that. The State Bar alleged in its amended complaint that Mr. Gingras made public disparaging comments about Judge Mata. The bar alleged that Gingras made disparaging comments in a notice for change of judge for cause, internet postings, and a podcast he posted on the internet. I mean, if you want to call it a podcast, sure. Mr. Gingras' petition for special action inaccurately asserted that the State Bar acknowledged factual disputes existed, but argued they were legally irrelevant because constitutionally free speech protections are not a valid defense in attorney disciplinary proceedings. The State Bar acknowledged that Mr. Gingras did not admit every allegation in the complaint and argued that lawyers have limited First Amendment rights when they make statements while engaging in the practice of law. Not all your statements, just while you're engaging in the practice of law. When you're acting as an attorney and not Joe Blow. Clearly, lawyers retain some free speech rights that may not be adjudicated in lawyer disciplinary proceedings. Right. Such as a lot of people don't like Nick Rekieta, even before his thing. And people would get mad because he would say shit. But he is allowed to say shit. And people would try to file bar complaints and all that. And nothing is done because he is not doing it while like acting as an attorney, being an attorney. He is doing it just being himself, who is a lawyer, just on the internet. Like, it wasn't about a case that he's involved in or a judge that he's in front of and different things like that. Let's see here. Clearly, lawyers retain. Okay, we said that. Let's see. CER 3.6 BC, permissible extrajudicial statements regarding general facts about a cause and statements required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by a lawyer or the lawyer's client. Lawyer conduct rules. Unprofessional conduct occurring while engaged in the practice of law may result in the imposition of disciplinary sanctions. Ethical Rule 8.2a states a lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, adjudicatory officer, or public legal officer, or of a candidate for election or appointment to judicial or legal office. Rule 41 requires a lawyer to 1, maintain the respect due to the courts and judicial officers. 2, avoid engaging in unprofessional conduct. The oath of the admission bar provides in pertinent part that lawyers, 1, will treat the courts of justice and judicial officers with respect. He has none for anybody. Will avoid engaging in unprofessional conduct, like look at me daddy. 3, will not advance any fact prejudicial to the honor or reputation of a party or witness unless required by their duties to their client or the tribunal. And stating and being disrespectful like that is not an honor or a duty to your client to talk like that. Will at all times faithfully and diligently adhere to the rules of professional responsibility. He is not professional in anything. Yeah, I don't know that Mike has responded to that augmented thing. And that's what I've understood is we're waiting on something, but he may not care. So I don't know what's going on with that. That's the only thing. Let's see here. The creed of professionalism of the State Bar of Arizona requires lawyers to conduct themselves in accordance with Code of Professionalism when dealing with clients, opposing parties, opposing counsel, tribunals, and the general public. Lawyers must be courteous, civil, both in oral and written communications. In negotiations, depositions, and other proceedings, they are to conduct themselves with dignity and not be rude or disrespectful. But rude is all Gingras knows. Argument. The court should decline jurisdiction of the special action. Footnote 5 says the State Bar's argument and this response are not presented in the same order or format that Mr. Gingras presented his arguments. The State Bar believes the issues and arguments are more limited than those identified by Mr. Gingras. Yeah, we need to narrow it down because Gingras is trying to argue something very, very broad. And it's like, no, we need to narrowly tailor it to you and what you're dealing with and what you're going through, which can have them answer some of the bigger questions. But it's about, are you being treated unfairly? And did you lose all your First Amendment rights, which we know you didn't. Factors supporting declining jurisdiction outweigh the supporting accepting jurisdiction. The court has special action jurisdiction in the State Bar disciplinary proceedings. Special action jurisdiction accepted to address application of evidence rules 408 and 613 in State Bar proceeding. The decision to accept appellate special action jurisdiction, however, is discretionary. Rule 12A. Rule 12B and C identify several factors this court should consider in determining whether to accept or decline appellate special action jurisdiction. Jurisdiction for this appellate special action should be declined based on factors set forth in Rule 12 because the factors and supporting declining jurisdiction outweigh the factors that support accepting jurisdiction. Factors that support special action jurisdiction. This special action was not designated for rule under Rule 13. Gingras does not assert any legal or evidentiary privilege or immunity from suit. The applicability of the First Amendment and Article 2, Section 6 of the Arizona Constitution to lawyers engaging in practice of law, not a matter of first impression. A lawyer may be disciplined if his public comment threatens to significant state interests. The good standing of the judicial system is such a significant interest. Generally, a lawyer may accurately criticize a sitting judge, but may not impugn the integrity of the judicial system or question the decisions of the judge. You can say, I disagree. I don't think the judge got this right. You can say that. You cannot accuse them of crimes and call them names. Let's see here. By making a profane and insulting remark in an ex parte communication with an arbitrator. And then they cited some case law. Arizona Supreme Court affirmed a hearings panel conclusion of law, which included findings that the lawyer violated the oath, the creed, Rule 41G, the precursor to those Rule 41B7 Arizona Rules Superior Court and ER 8.4D by belittling Judge Griffin, accusing him of not reading what he submitted and directly invectives at him, none of which were objectively or reasonably necessary. Does Gingras ever do anything that is objective or just necessary, period? The Arizona Supreme Court affirmed a hearing panel's conclusion of law, which included findings that the lawyer violated those oaths, the creed, and those rules based on statements made in the pleadings and motions while representing a client, which is similar to what Gingras did here. The applicability of Arizona's anti-SLAPP statute in lawyer disciplinary case is an issue of first impression, but it is one that can be resolved based on specific facts in this case. Although the applicability of First Amendment, Article 2, Section 6 of the Arizona Constitution and Arizona's anti-SLAPP statute as they pertain to lawyers engaged in the practice of law are issues of statewide importance, this case raises as applied challenges to certain ethical rules that are specific to the facts of this case. The issues this case presents, therefore, are not issues of statewide importance. Yeah, in general, we want to know about can this hello, no thanks, okay. Can this anti-SLAPP be used in attorney disciplinary hearings in Arizona, like it can be in other things? But there's still rules that anti-SLAPP doesn't mean you get to just do whatever the hell you want to. Okay, thank you, TX. I appreciate it. Constitutional limitations imposed on lawyers engaged in practice of law do not raise issues that tend to evade review or become moot before an appeal. The case does not involve the welfare of children. This court's special action resolution of constitutional restrictions on lawyer speech will not materially advance the efficiency management of this case. The PDJ's granting in part of the State Bar's motion for partial judgment on pleading did not resolve all allegations in the amended complaint. Yes, but he says that all of his issues are First Amendment issues, and none of what you said has anything to do with anything other than First Amendment. For the most part, is his argument on most of those things. He had the right to do everything he did. I guess he did have the right to do it all. Doesn't mean that he's free from the consequences, but he thinks he should be able to do whatever he wants with no consequences. Let's see here. Therefore, the remainder of the allegations of misconduct, alleged violation of a court order, and non-meritorious claims made on appeal will be addressed by a hearing panel, regardless of this court's decision whether to accept or decline special action jurisdiction. Following a hearing on the merits, one or both parties may appeal. So he's saying it's too soon to try to appeal the issues that haven't been decided yet. The special action does not raise an issue concerning the PDJ's decision that cannot be justified under any rule of law. As noted below, the PDJ appropriately granted in part State Bar's motion for partial judgment on the pleadings and denied Mr. Gingras' motion to dismiss. Factors that supporting declining special action jurisdiction. Gingras unreasonably delayed seeking special action review of the PDJ's granting of the State bar's motion for partial judgment on the pleadings. The PDJ entered an order granting in part the state bar's motion for partial judgment on the pleadings on April 14th, 2026. He did not file a petition for special action review until July 22nd, 2026. Had Mr. Gingras promptly sought and obtained special action relief regarding that issue, the parties could have timely undertaken discovery into his disparaging comments about Judge Mata. And he'll have excuses about why that is. I'm not saying that some of them are legitimate excuses. I'm just saying. Mr. Gingras argues that he raised material fact disputes that should have precluded judgment as a matter of law. Special action jurisdiction, however, is not appropriate to resolve disputed facts. Special action jurisdiction appropriate when issued does not turn on the resolution of disputed facts. Thus, if the court were to accept jurisdiction based on disputed facts, this court would simply result in a remand for further factual development, not in the resolution of a constitutional issue that Mr. Gingras claims to make. That is an issue of statewide importance. The PGJ resolved the constitutional and anti-SLAPP issues, which are incorporated into the lawyer disciplinary procedures. The fact supports declining special action jurisdiction. To the extent that Mr. Gingras argues that lawyers have the same First Amendment protections as members of the public, that issue has been clearly resolved by settled law. See above cases addressing limitations on lawyers' First Amendment rights. Yeah, but they still say that that's still unconstitutional. The issue raised by Mr. Gingras are equally appropriate to address on appeal. Gingras claims that partial judgment on the pleadings was improper because he denied various allegations in the complaint. Because the PDJ found sufficient factual grounds based solely on the pleadings to conclude that Mr. Gingras engaged in misconduct, the sufficiency of the admitted allegations is a matter of more appropriate for appeal. Like, this is not for this, like, special action appeal. He can make those arguments when he appeals regularly. No, not right now. That is not for special action court. That is for if you lose and you need to appeal, you can deal with that after everything has concluded, like you would in most other cases. The court's resolution of the issues raised by Mr. Gingras will not materially advance the efficiency management of this case. As noted above, the court's resolution of issues raised by Mr. Gingras will not resolve all allegations of misconduct, thus necessitating a substantive hearing before a hearing panel to address the remaining allegations of misconduct. In addition to factors set forth in Rule 12C, if this court determines there are factual disputes that preclude it from determining whether the PDJ appropriately granted in part the state bar's motion for partial judgment on the pleadings, the appropriate remedy is to remand the matter to the PDJ. If this court declines special action jurisdiction, Mr. Gingras may appeal the PDJ's ruling on the constitutional issues, the applicability of anti-SLAPP statute to a lawyer disciplinary proceeding, and the state bar's motion for partial judgment on the pleadings following a hearing on the merits of remaining allegations of misconduct. Mr. Gingras could raise all issues on appeal, both those the PDJ has already addressed and those that may arise during a hearing on the merits. It is more efficient in this case for this court to decline special action jurisdiction than bifurcate the issues for this court to consider once the special action and therefore on appeal. The court is not required to accept special action jurisdiction simply because one or more factors support accepting jurisdiction, especially when the factors that support declining jurisdiction outweigh these factors in support of accepting jurisdiction. So it's like, don't accept this. Tell him to take it up on appeal. We don't even need to really fully hear this out. Although Gingras Mark Randazza should be getting their response out fairly shortly. Gingras noted in his petition that this court has held that interlocutory review is especially appropriate when a case presents a substantial First Amendment issue for which a party has a case dispositive First Amendment defense. As set forth below, Mr. Gingras does not have a case dispositive First Amendment defense to the allegations in the State Bar's complaint. He also is incorrect in his assertion that if the court declines jurisdiction, he will be required to litigate the remainder of the case under a fundamentally incorrect legal standard that is inconsistent with controlling state and federal constitutional precedent. As noted above, lawyers' First Amendment rights may lawfully be limited while engaging in the practice of law. Based on the foregoing analysis, this court should decline special action jurisdiction. The presiding disciplinary judge properly granted in part the State Bar's motion for partial judgment on the pleadings, finding that Mr. Gingras violated ethical rules by making disparaging comments about Judge Mata. Gingras admitted numerous allegations in the State Bar's complaint, partially admitted other allegations, and denied still others. Denied allegations were unnecessary to establish a violation because there was so many instances. Yeah, he's like, yeah, I said these things, but it was my First Amendment right to say those things, and I shouldn't be able to be disciplined for them because it's my right. He admitted to making those. He says he made him for this, but that doesn't mean that they have to agree with his assertion. That they were like, okay, you admitted to saying these things. These things were not appropriate. No matter what you think your reasoning is, you can't act like this. If you would have said, no, I didn't say those things, then it would be different. But you were like, yep, I did that. Yep, I did that. Yep, I did all those things. But here's why I did them and why I'm allowed to do whatever I want. Mr. Gingras asserts the State Bar's primary position of this attorneys surrender their First Amendment rights upon admission to the bar. The State Bar has never taken such a broad position. Exactly. The state does, however, assert that the bar members' free speech rights are limited when they are engaged in the practice of law. For example, lawyers' free speech rights are limited when, as here, they make disparaging comments about a judge during the pendency of a case in which they are involved. That's why you shut up and don't talk about cases you're dealing with. Don't talk about your own cases during the dependency of them. Mr. Gingras incorrectly asserts in his petition that the PDJ granted the State Bar's motion for partial judgment on pleadings because his First Amendment rights and constitutional defenses failed as a matter of law because attorneys do not enjoy the same constitutional protections for free speech as other citizens. That's what Gingras said incorrectly. Rather, the PDJ found that Gingras had not asserted that the language he used in the disparaging Judge Mata was objectively and reasonably necessary to advance his client's matter. She also noted that the oath of admission to the bar and the lawyer's creed of professionalism require lawyers to, among other things, treat judicial officers with respect, avoid engaging in unprofessional conduct, be courteous and civil both in oral and written communication, and conduct themselves with dignity and not be rude or disrespectful. And Bruce is always saying, why has he got to be so rude? Why you got to be so rude? Mr. Gingras generally argues the rules of professional conduct must yield in all circumstances to First Amendment free speech rights. That is not an accurate summary of the current state of law, which Gingras is like, but it should be. The First Amendment, like every other amendment, is not absolute. Citing case law, lawyers in pending cases are subject to ethical restrictions on speech to which an ordinary citizen would not be. Lawyers disparaging comments about judges, particularly when they are involved in proceedings before the judge, may result in a public losing confidence in the impartiality of courts. Unwarranted public suggestion by an attorney that a judicial officer is motivated by criminal purposes and considerations does nothing but weaken and erode public's confidence in the impartiality adjudicatory process. False statements impugning the integrity of the judge erode public confidence without serving to publicize problems that justifiably deserve attention. False statements or statements made in reckless disregard of the truth that disparage a judge erode the public confidence in the judiciary and thereby undermine the administration of justice. Generally, a lawyer violates ethical rule 8.4d, where the lawyer's conduct negatively impacts the public's perception of the legal profession. The U.S. Supreme Court has held that the state may adopt lawyer conduct regulations that may limit lawyers' First Amendment rights. Moreover, the court's decision dealing with the lawyer's First Amendment right to solicit business and advertise have not suggested that lawyers are protected to the same extent as those engaged in other businesses, but have balanced the state's interest in regulating a specialized profession against lawyers' First Amendment interest in the kind of speech at issue. They bring up Gentile, trial publicity, ethical rule void for vagueness. The state bar did not allege that Mr. Gingras violated ER 3.6, Arizona's trial publicity ethical rule. Nevertheless, it reflects that lawyers' First Amendment rights may be limited while engaged in the practice of law. Arizona Court of Appeals has addressed the limitations of lawyers' free speech rights, stating resorting to epithets or personal abuse is not in any proper sense communication or information or opinion safeguarded by the Constitution. There are certain well-defined and narrowly limited classes of speech, the prevention of punishment of which have been thought to raise constitutional problem. Let's see. The court has also addressed limitations on free speech in the context of the practice of law. Lawyers who are candidates for judicial office may make fair comments on the sitting judge's fitness, so long as the comment does not call into question decisions of the courts or question the integrity of the judicial system. For example, a lawyer may criticize a judge for unnecessary delay in reaching a decision by saying, I don't know why she's taking this long. She's dragging this out. Why can't the judge just decide now? Like, they're allowed to say that. You can say, I don't like that decision. I don't agree with that decision. Respectfully, I disagree, Your Honor. I accept your ruling, but I don't agree with it. Proper avenues for questioning a decision include appellate route and disciplinary proceedings where appropriate. Yeah. If you have a problem with what happened, go to the appeals court, write a bar complaint. What we condemn is conduct which denigrates the judicial system as a whole and undermines the public's confidence in it. The dissent in the case notwithstanding, we believe that our opinion here today in no way diminishes the First Amendment freedoms enjoyed by lawyers. Mr. Gingras' comments about Judge Mata outside the courtroom are properly subject to Supreme Court Rule 41 and the rules of professional conduct because they were made while he was a counsel of record in a case which was still pending. In one instance, one of Mr. Gingras' disparaging comments was included in a document he filed on his client's behalf. He really does. He thinks he can just do whatever. Gingras's disrespectful and disparaging comments about Judge Mata were unnecessary. Yeah, you didn't need to say all that. You could say you were unhappy with it. You thought that there was things that, but you did not have to talk in a degrading way. There were ways you could put in your file for a new judge, bias, whatever, and not just be just gross. There's a professional way to handle it, and it wasn't the way you did it. Yeah, he could have simply commented on proceeding without editorializing about Judge Mata or asserting fact matters for which he had no or limited information about, because he has none. That's speculation. The PDJ noted in her April 14, 2026 order that it was not necessary for Gingras to disparage Judge Mata to competently and diligently represent his client. Right. Mr. Gingras claims he did not violate ethical rules because he was diligently representing his client. Yeah, but you don't get to just say things however you want to. You have to be professional. You have to be classy. You can be sass. You can have sass with class. But you can't just, you just can't be the way you were. The belief, however, is without merit. This court has stated respondent says that he would not have behaved as he did if the judge had acted properly. You don't need to act that way because you don't have to stoop to certain levels. You don't have to stoop to other people's levels. And Judge Mata didn't even stoop to any level like that. But even if she had, you don't have to. You're supposed to be above that. Regardless of respondent's belief that his actions were necessary to protect his client's interest, his behavior was inexcusable. I agree. The court noted that it was most concerned with, this is another case, refusal to accept that his conduct cannot be justified by any perceived unfairness. The court addressed the issues in other cases. Zealous advocacy has limits. It clearly does not justify ethical breaches, right? You can't just get up and cuss out a judge or say racist things because, like, if your client is, the judge is white and your client is black, like, you couldn't get up and just call them racist things and call them racist and all this other stuff and start cussing them out just because you think that they are being biased against your client or ruling against them because they're of a color. You can get that point across without being unprofessional. But Gingras always goes below the belt. U.S. Supreme Court has also addressed this issue, stating that model rules of professional conduct confirm that the legal profession has accepted that an attorney's ethical duty to advance the interests of his client is limited by equally solemn duty to comply with the law and standards of professional conduct. I mean, even in schools, kids have a code of conduct. They have to adhere to. They can get in trouble. Even though they have their First Amendment thing, it's not like they can't get it kicked out of classrooms if they say a bunch of stuff to a teacher or to another student. They can be disciplined for it. Are they going to go to jail for it? No. The State Bar is not required to prove that Mr. Gingras knew that his comments about Judge Mata were false. Rather, the bar need only prove that he acted with reckless disregard for the truth or the falsity of his statements. The inquiry to be made is whether Gingras' factual basis for making the comments was objectively reasonable, which I don't think they were. An objective standard is used to determine if demeaning language constitutes unprofessional conduct. Right. And if the Supreme Court comes back and says, no, you can talk however you want, and the State Bar can't do anything to you, there would be so much chaos in the court. So much chaos in the court if people were just allowed to go rogue and act unprofessional. This is why most of this is not going to be successful for Gingras. Let's see. Motion for partial surrender to the president because he denied in his answer that he made any statement that was false or made any statement with reckless disregard for the truth. To sustain an allegation that Gingras violated, the State Bar must prove that Gingras knowingly made false statements or made statements with reckless disregard for the truth. And those rules do not require proof that Gingras made false statements or made statements with reckless disregard for the truth. Therefore, the PGJ's finding that he violated may nevertheless be affirmed. Cases cited by Gingras in support of his argument that the U.S. Supreme Court has repeatedly rejected limitations on lawyers' First Amendment rights pertained to a bar applicant's refusal to answer a question whether she had ever been a member of the Communist Party or any other organization that advocates overthrows. Lawyers' right to defend. Yeah, those have nothing to do with what we're dealing with. Bar counsel found that attorney engaged in misconduct by making statements with reckless disregard while disrespecting judges by making derogatory and false statements which were not protected speech. The bar court stated, although attorneys are entitled to protection of the First Amendment, even as participants in administration of justice, disparaging statements amounting to an attack on honesty, motivation, integrity, or competence of any judge may be subject to attorney discipline. Let's see. Barr and Olin stated that other courts had noted that reasonable speech restrictions may be imposed under certain circumstances upon attorneys, given their special status as officers of the court. The court also stated statements characterized as rhetorical hyperbole, and statements of opinion that are incapable of being proven as true or false are not sanctionable unless such statements could reasonably be understood as declaring or implying actual facts which themselves are false. Although bar courts stated that truth is an absolute defense to any statement made by an attorney that impugns the honesty or integrity of a judge, at least some of Mr. Gingras' comments were not truthful. Also warranting a finding that Mr. Gingras engaged in unethical conduct is the demeaning and disparaging manner in which he asserted that Judge Mata acted inappropriately. For example, Mr. Gingras included the following on social media post. Annoyingly, but not surprisingly, Judge Mata screwed up the form of final judgment. It doesn't contain stuff required by the rules. Shocker. We asked her to fix, we could ask her to fix this, but it would be a waste of time. Right. Saying that she won't fix things. She won't follow the ethical rules that she is bound by. Yes, she would. And guess what? She did fix stuff. She did her duty. Then Mr. Gingras also alleged that Judge Mata committed a crime. Gingras failed to thoroughly research whether an Arizona Superior Court judge may modify the terms of a domestic violence restraining order issued in California. He further posted on the internet that Google is not a valid legal source of evidence unless your case is assigned to Judge Mata. The statement implied actual facts that were without factual basis or amounted to an opinion that could be proven false. Finally, Gingras stated the following during a podcast. If Judge Mata was a person who cared about the rules, she would have sanctioned opposing counsel for making false statements about the law. The statement either implied that Judge Mata did not care about court rules or expressed an opinion that could be proven false. Gingras' comments stated and implied actual but false facts about Judge Mata. Mr. Gingras' statements were nothing more than mere conjecture. And in the Olin case, they found that, the person violated the duty to maintain the respect due to the court's justice or judicial officers in the violation. 3, the presiding disciplinary judge properly denied the motion to dismiss based on anti-SLAPP statute. And he says SLAPP is an acronym for Strategic Lawsuit Against Public Participation. Allows a person other than a state actor or an intervener to file a motion to dismiss a legal action if it was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of constitutional rights. Lawyers retain First Amendment rights, but their free speech rights are limited while engaging in practice of law. Not just in general, just while they're engaging in the practice of law. And do not always enjoy the same rights as the non-lawyers do. C. Riley. A lawyer is held to a narrower standard of free speech than a non-lawyer when discussing the judiciary. Ziman. Misconduct found based in part on profane and insulting remarks. That was Levy. An objective standard is used to determine whether demeaning language constitutes unprofessional conduct. Martinez. Gadget. Misconduct found based in part on unsubstantiated contentions about judge. Assuming the anti-SLAPP statute applies in lawyer disciplinary cases, Mr. Gingras nevertheless may not rely on it for dismissal of State Bar's complaint because lawyers do not have a constitutional right to disparage judges in a pending case in which they are involved. The statute requires the lawful exercise of right of petition, the right of free speech, emphasis added. My nose. Let's see here. Hello, Israel. Let's see. No proof of anything. None. Let's see here. Furthermore, Mr. Gingras has not established prima facie proof that the State Bar's complaint was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of constitutional right. Yeah, he thinks that Bar Counsel Jim Lee just has a bone to pick with him. The court must determine whether the anti-SLAPP statute applies to the lawyer disciplinary case in which the State Bar alleges that a lawyer has made disparaging comments about a judge in a case in which the lawyer is involved. This raises an issue, as noted by Mr. Gingras, whether the state legislator adopted the anti-SLAPP statute invades the province of the court's supervision of the practice of law. Hold on just 1 minute. 1 second. Oh my God. When was that? Oh God. Okay, well, we got the gist of it, right? It's been a while. Okay, no proof of anything. Okay. Well, we'll sum it up here. Ugh. Well, I don't have storms here, so I don't know. But basically the state bar is saying that he doesn't have the right to that he doesn't have the right to make the comments that he did, and that if it was just regular constitutional speech, then he wouldn't be being disciplined with it. But his speech isn't constitutionally protected speech. And that there are limitations. And then the very last thing he addressed was the fact that Gingras wanted to, have a new PDJ judge when this gets remanded back down to them. And it will. But that there was no reason for that. But he just assumes, because he is a negative Nancy, and thinks, well, this person, because I tried to get them overturned and pause their thing and went against them, she's going to be biased against me. There's no proof of that. I think he just doesn't like her, and wants a new one because she has griped at him for not following rules already. But that doesn't mean she's biased against him. And so I don't think that they are going to say that there needs to be a change of judge when it gets remanded back down, because she hasn't done anything. She's even like, you know what? If you need to appeal it, go right ahead. Like, I'm willing to work with you, because I think this judge is interested in knowing too how anti-SLAPP would affect it. I have not seen anything that tells me that she is against Gingras and pro state bar. Because I'm sure the judge is going to say, there are things that I think the state bar is reaching a little bit on, or, this thing the state bar said and this thing that the state bar said, I don't necessarily agree with those, or they're a little different from me. So, but I have this example which could prove this, but I don't agree with everything. She could agree with some of it, and I think she did fairly somewhat agree with Gingras in not granting certain things about, let's flesh out this before his time order. But he thinks anybody that disagrees with him, or that he doesn't agree with, is going to automatically not be fair to him. And that's just not how it is. So I'm not a fan of him, but I will give him points when I might agree with something, or even if I don't necessarily agree where he's coming from, I am interested to hear what's going to come out of it. But yeah, he acts like a toddler and a child. He doesn't get his way. And I don't know why he is the way he is. Like, we know why Laura's the way she is. we've seen why that's the outcome. Even though all people that do things, you can't say, oh, they're parents. No, not everybody that does bad things has to do with the way their parents raised them. So, but that is it. We are caught up on, as of right now, things in the Owens-Verse. So we went over the body cam footage for the wellness check. We did the bankruptcy things, and we are caught up in this. And like I said, Gingras's reply to this should be coming out soon, because I think he said he had like a week or 10 days or something like that to respond once they put theirs out, because he was like, look, they didn't even have to accept it, and they're allowing people to respond and then me to respond. So, and then we wait for the special action people to rule. We don't have a hearing until the end of the month, I believe. No other filings have come out. So, of course, things that come out in this case, we will bring them to you. Oh, I wanted to check something so I could definitely... So what we have coming up is there's some things in Matthew Farwell, Sandra Birchmore. There are things that have been put in that case that have come out that I need to go over. And then there is a hearing. Let me see. I haven't seen... Still haven't. Okay. Even though that Carmelo Anthony has his meeting, his motion for new trial hearing is next Wednesday and Thursday. So about a week from today. I haven't seen a response from the state on the motion to recuse the judge or the motion for a new trial. Like I said, those are probably just going to get denied. But the state may not respond. They may just show up to the hearing and just put their arguments there. So we'll see with that. And then we will be continuing with Sharilla stuff. So we've got Sandra Birchmore stuff and Sharilla stuff. And when I have updates in this case or in the Carmelo Anthony case, right now, those are the main ones that we're doing. We will bring those to y'all. Also, I am going to be doing a very personal video due to the stuff happening with the Lindsay Clancy case. It's not going to fully be about, it's not really going to be about Lindsay Clancy. It is going to be about my journey and some of the stuff that I have realized that I didn't even think about until now, really. How actually screwed up that was, thinking back about it. But I do want to share my insights about that and my mental health journey as far as some postpartum stuff that happened after my son. And I have his permission to talk about it. So thank you for hanging out with me, and I will see you guys next time. Don't forget to hit that like on your way out and subscribe.